It's your friend Rick. It is May the 26th, 2018. If you need to reach me, my email is rick0327 at me.com. Okay, so my big conspiracy isn't a conspiracy. God dang it, but that's a good thing. All right, so what happened, I believe, uh, is I think because I used to click on a lot of the links and it wouldn't take me anywhere, and I just believe that the website was left up there, and I'm not sure. I'm just gonna guess that the domain owner wasn't paid what they were supposed to be paid, and they forgot. All right, so then when I showed you guys all the extra traffic of us going there, they must have smartened up and realized what was going on. They shut the channel down. I'm guessing now you guys all owe a thanks to my subscriber. Las Vegas Vocalist is his name. He's in the comments section. He took it upon himself to reach out to the owner of the website, and the owner of the website put it right back up as you can see right now. And I just clicked on all the like right here, we'll click on bad judges list, all right, and it comes up. All right, that wasn't coming up, by the way. I believe these guys are out of the Northeast, the New England area. Okay, click on restraining orders, all right, all that stuff wasn't coming up. So this was a good thing. So now we have this channel, this website up and running at 100%. Thank you guys. Thank you, Fathers United, and I will be sending you guys a donation for appreciation. All right, and Las Vegas Vocalist, thank you, my brother. I got the best subscribers. I can't tell you how many guys reach out to me with excellent information that I put to good use. All right, hold on a second here. And by the way, what we're going to be talking about in this video is judicial notice. All right, I found by accident again judicial notice. What judicial notice is that you're noticing the court of a fact, an adjudicated fact. And what it does is it takes away the judge's discretion, because what you're doing is you're really introducing it as evidence under Federal Rules of Evidence 201 subsection D and state law equivalent. So what you would do is you would look up in your state, state of Maryland, judicial notice law, and just Google it and come up and add it. Okay, that way we're covered. But remember, we know that the federal laws apply in state courts under Howlett versus Rose, and I believe McCulloch versus Maryland. But let's stick to Howlett, Howlett versus Rose, ROSE, which also cites the supremacy clause is the reason why federal laws apply in state courts. All right. So I'll show you. I'll show you right here. All right, my one of my guys showed me this. Okay, the Seventh Amendment is still alive and well. That is your right to a trial by jury in civil cases. We are in a civil case, and it's for any controversy of $20 and more. But shh, they don't want you guys to know this. This is why they're fighting us. Okay, this is why they will ignore us with this. Well, guess what? It's still alive and well. Some judge claimed that because Puerto Rico is a what is Puerto Rico considered again? A province, basically. What is it considered again? A commonwealth. All right. Puerto Rico is considered a commonwealth. So because they're a commonwealth, they're not entitled to our Constitution. Well, that's not true. Okay. So the case is Gonzalez Aruzin versus Caribbean City Builders. And basically, the Seventh Amendment is alive and kicking. This is 2014. All right, my man Joe showed it to me. So what you could do as an example of a judicial notice, you can judicial notice the court of the fact that the Supreme Court in this decision here cited that the Commonwealths are entitled to the Seventh Amendment. Okay, well, the Seventh Amendment is entitled, the Commonwealth's entitled. That means the Seventh Amendment is alive and kicking, and that we're entitled to it. All right, it's a fact that we have rights secured by the Constitution, the Bill of Rights. All right, if you go on many channels out there, you know, doing your research, there's a lot of good channels out there. I'm not going to name them all. I mean, I'm not talking about YouTube channels. I'm talking about internet channels. And the ones that I respect, we all say the same thing. Where did the right to a trial by jury go? When was it eliminated from the courts? When did that happen? It didn't happen. It hasn't happened. It's still there. So remember, I told you guys. Then I found a Supreme Court decision, Hoboken land, right, versus whatever the hell it is. Fucking memory shot skill, excuse me. For a guy that does this, you think I'd have it memorized. It's in, hold on a second. And I have a judicial notice set up. Memorandum right here. All right, and what you do is when you submit your paperwork, you're going to submit in support of your paperwork. You're going to submit a memorandum of laws, judicial cognizance. It's the same thing, judicial notice. All right, and the way you would update it, whenever the hell this thing loads up, is you're gonna add the state law for judicial notice. All right, and what I'm trying to do is I want to show this to you, but I also want to show you the law, the Hoboken law that says that the due process is a judgment by peers. How do you get a judgment by peers? You get a trial by jury. Okay. All right, so right here you would judicial notice all of these. It's a fact that the Article 1, Section 9, the privilege of writ of habeas corpus shall not be suspended unless in cases of rebellion or invasion. That's it. It can't be taken away from you. So any judge that takes it away from you with their bullshit summary dismissals, that one-line dismissal, they're trespassing upon you. It's that simple. It's a trespass. Whenever you're deprived of a right, it's a trespass. By the way, you would not be wrong if you're in the court, their version of a court, and you're before one of these fake judges, these hearing officers, the magistrates, support magistrates, commissioners. You are allowed to say, objection, you are trespassing upon my rights. You have no personal jurisdiction over me. You are a non-judicial person. I can only be judged by my peers, and you are not a jury of my peers. One of my subs, you'll see it in the comments section, these effing brazen judges told him, I'm your peer. This is that. Some of them are real wise asses. One, I got an email 2 days ago where my man, Willie told me that the judge said, because I'm a judge, that's why. I mean, these guys are out of control. That's why it's important for you to have the knowledge, to come back at these people. Okay? Donna just sent me an email. Donna held her own. A fake judge tried to do that to her. She held her own and got a postponement. And when you get a postponement, that means you have from now until that date, to come up with a better plan and really stick it to them. Okay? All right. Here it is. Murray's Lessee versus Hoboken Land. The words due process of law were undoubtedly intended to convey the same meanings as the words by the law of the land. All right? But by the judgment of his peers or the law of the land. Anything not by a judgment of your peers is a void judgment when your life, liberty, and property is being taken from you. So you ever notice that they don't hesitate in giving you a trial by jury if you're facing 20 to life? Well, it's the same burden of proof, by the way. Whether you're facing 20 to life or you're involved in a civil case, it's basically the same burden of proof. Okay, if you're going to be deprived of more than $20, a controversy of more than $20, you're entitled to a trial by jury under the 7th Amendment. The 6th Amendment is for criminal matters. Okay, 7th is for civil. Well, child support is considered a civil matter. All right, I think it's unconstitutional anyway. All right, so anyway, I got sidetracked. Oh, another subscriber of mine, John Valdez, showed me a case law, and basically the same thing. We're going to use, and this is how I found the judicial notice. John got me in that direction. Okay, hold on a second. What it is you use the judicial notice under Federal Rules 201 subsection D to give notice to the court that the Supreme Court said in Crandall versus Nevada in 1878 thereabouts, we as natural individuals are entitled to free access to the courts. Remember, I've mentioned to you guys in the past that the fees for the courts were really initiated because of lawyers. But you know what the fees are really for? They really go into like a secret trust for these judges. Shh, don't tell anybody. Okay? Go look up Richard Fine. Richard, obviously, Fine. He was jailed because he pointed out that the judges in the county of Los Angeles were all being compensated because all of the money from speeding tickets, traffic tickets that were put into a trust, and they were being paid. So how can you be impartial? So if you know that traffic fines, the more traffic fines you have, the more money's put into this trust, everybody's going to be guilty. Well, that's what he came up. And there's an example of an honest lawyer being jailed by a judge. Okay. All right. This is an example of judicial notice. Okay. And before people start inundating me, hey Rick, can I get a copy of that? You know, it's not ready yet. Okay, and if you don't have it, if you're one of these guys that got my paperwork 6 months to a year ago, you're gonna have to come up with some little extra money. I'm sorry. Okay, because I put a lot of time into this stuff. All right, and I'm also considering, when you send me a donation, I'm gonna give you X amount of emails, and then after that, you're gonna have to start compensating me for that. I can't tell you how many emails I get, especially at nighttime. You know, it's getting a little out of control. I mean, listen, it's nice to be wanted, but I have a life too. You know, I mean, some of these emails, one guy got mad at me. Oh, I got to show you this email. One guy must have been drunk. Hey, is your paperwork gonna work, or are you gonna rip me off like my wife? This is what he said to me. And then when I didn't respond to him, he was like, "Oh, I guess because you didn't respond to me means you were gonna rip me off." That guy was a real fucking asshole. We'll give you an example of some of the assholes that I deal with. I mean, this guy. I look up asshole in a fucking dictionary, and the guy's face is looking right at me. That's the kind of asshole he is. Excuse my language, but the guy was a real jerk. So you take judicial notice on the federal rules 201D to waive filing fees, the petitioner to access the court for justice. See, you have a constitutional right to petition the court. Remember I mentioned that, well, I don't even understand how they're charging us $5 for a writ of habeas corpus. Well, here's the reason why. They're not supposed to. You have a constitutional right, but as with everything else, lawyers aren't going to tell you this. Now, lawyers are supposed to pay because they're professionals. They're not considered a natural individual. They're a legal entity. You and I were natural individuals. That's why I don't like anybody changing their name. One of my guys last night, he was thinking out of the box. He didn't do anything wrong, but I'm just like, dude, don't give yourself a title. Just call yourself a man. That's basically it. Okay, so here it is right here. But also to its judicial, living as we do under a common government charged with the great concerns of the whole Union, every citizen of the United States, from the most remote states or territories, is entitled to free access, not only to the principal departments established at Washington, but also to its judicial tribunals and public offices in every state in the Union. You got me? Free access to the courts. This is going to be huge for us. Okay, they're going to fight us, but guess what? What judicial notice takes away discretion, because now it's introduced as evidence into the court. Also, when you use judicial notice with your petition, you're providing evidence to support your claim. That way they cannot dismiss your claim for failure to state a claim. Okay, so judicial notice, Federal Rules of Evidence 201, right here it is, right there. Right, and here's what I'm going to do. I'm going to do this nice and slowly, all right? And those of you out there, you want to copy this down for free of cost, right ahead. That way you can access the courts for free. It's your gift from me, thanks to John Valdez. Thank you, Johnny. Good man. This is the kind of guys that I have who are subscribed to my channel. I got Marlon, I got Josh Brown, I got Phil in Florida. And if I forget you guys, please don't get angry with me. You see, my memory is shot. Okay, nice and slow. Right, there's Howlett versus Rose. Federal law is enforceable in state courts not because Congress has determined that federal courts would otherwise be burdened. That's. And by the way, there are opinions out there like that. Well, they did that with the indigents for free access to the courts. They were worried, well, if that's the case, and all the federal prisoners and state prisoners will be inundated in the courts. Well, too damn bad. If you have people have rights to file petitions, too bad. Okay? Take some of your interns and all these other privileged college students from privileged families who work as clerks to these judges who got the inside scoop that you and I would never get. Have them read it. Okay? But because the Constitution and laws passed pursuant to it are as much laws in the states as laws passed by state legislature, the Supremacy Clause makes those laws the supreme law of the land. So, guys, how many of you out there have used my paperwork and these state judges say, federal law doesn't count in the state? That's, by the way, they do that as a test to see if you know what's going on. And a lot of you get caught with that. All right? So, now you know that federal laws apply in state courts. Okay? All right, that's it, guys. All right, again, I'm going to do it again, nice and slow. All right, you can copy this down and do it yourself. There are many of you that have done that with my paperwork. And here's another thing. If you see paperwork on my channel, when I'm doing a video, it doesn't mean You know, hey Rick, I saw this paper. I don't have it. It doesn't. Maybe you're not entitled to it. Maybe it's just on the computer for me. Okay. I don't supply study materials anymore. I used to. They had one jerk bust my balls because he thought he was paying for it, and I'm like, no, it's anything that's free on a computer. I don't charge you for. But anyway, it's another story. All right. All right. So that's the end of the video. All right, guys. And remember, judicial notice. You can even do that. You could even do that when you're inside the court. Say, I am providing. I am giving the court judicial notice that. By the way, because it's a fact that your rights are secured by the Constitution. That's a fact. That's an adjudicated fact. There are plenty of case laws out there that First Amendment, Second Amendment, Third Amendment, Fourth Amendment, Fifth Amendment, Sixth, Seventh. There's adjudicated laws all over the place. Okay, so you're allowed to say the court must take judicial notice of the fact that my rights are secured by the state and federal Constitution or Constitution for the United States. Okay, I'm not going to get into that. Um, and you should do that. And uh, court, on the Federal Rules of Evidence 201 subsection D, court must or the state, take it upon yourself to learn the state law for judicial notice and invoke it. Say, I'm introducing as evidence on the judicial notice adjudicated fact that blah blah blah, case law this, case law that, and it's supposed to eliminate the judges or fake judges' discretion. They must take judicial notice. Okay? All right, guys. I'll talk to you guys later.